Hello and welcome to today's webinar. My name is Robbie and I will be in the background answering any WebEx technical questions. We have a few housekeeping items before we get started. If you experience technical difficulties joining the WebEx session, please dial 1-866-779-3239 or you can message the WebEx producer using the Q&A panel. During the presentation, all participants will remain in a listen-only mode, and as a reminder, this event is being recorded for rebroadcast. We will be holding a Q&A session at the conclusion of today's presentation. We encourage you to submit written questions at any time during the presentation using the Q&A panel at the bottom right of your screen. Please type your questions into the text field and hit send, and please keep the drop-down as all panelists. With that, we invite you to sit back, relax, and enjoy today's presentation. I would now like to introduce your speaker for today, Josh Rich. Josh, you now have the floor.
Thank you, Robbie, and thank you to all of you for attending. Wherever you may be, locked in or in the office, I really appreciate you attending in a very different world than when we originally scheduled this webinar. I also appreciate your optimism that trade will come back and be important. And of course, it will be important because laws will have to have been changed in light of the trade agreements that we're talking about today. So first, one of the most important things for many people here on the line is how to get CLE credit. So please note that all the registrants for today's webinar will receive an email from MBHB within 24 to 48 hours containing a PDF copy of the PowerPoint that I present today and a link to the archived audio version of today's presentation. And if you are seeking CLE credit for today's presentation, please note that there will be 2 randomly placed PowerPoint slides inviting participants to complete a simple online poll question. It's typing in a word when the slide comes up. You must complete both poll questions in order to confirm your active participation and thus be eligible to receive CLE credit. And I will pause upon those slides to give you the opportunity to look and enter the poll answer at that time. The poll question will remain open after the slide changes, though, so that you will be able to answer even if the slide comes down. We encourage you to submit any questions you may have during the webinar presentation using the WebEx online question submission module. That's the Q&A to the bottom right. Time permitting, we will attempt to address any submitted questions at the end of the webinar. If time does not permit, we will respond offline after the webinar. We have a lot to talk about today, so thank you, and we'll see if we can get to any of those questions. So the major topics we're going to talk about today start with the context of what the existing trade regime is. And really, for a lot of the requirements, nothing negotiated during this presidential term has come into effect. So right now, we're governed by a lot of the standards that NAFTA, the North American Free Trade Agreement, put into place. But there's also another key trade regime that plays a big part in all of what we'll be discussing. And that's the Trans-Pacific Partnership, or TPP, and its successor for all of the signatories of the TPP other than the U.S., which is referred to as the CPTPP, or the Comprehensive and Progressive Agreement for Trans-Pacific Partnership, sometimes also known as TP11, because there were 12 parties to the TPP and the U.S. is not a party to the CPTPP. But the 2 big ones that have come out most recently are the USMCA, which is the United States, Mexico, and Canada Agreement, and the U.S.-China Bilateral Agreement, formally named the Economic and Trade Agreement between the governments of the United States of America and the government of the People's Republic of China. This is the agreement signed just this year between the U.S. and China. So let's start with NAFTA. NAFTA has been around for over 25 years. It was negotiated starting with the first Bush administration and went into effect in 1994 under President Clinton. And it was the first important multilateral agreement that the United States is a part of. It's an agreement between the United States, Canada, and Mexico. It replaced an earlier bilateral agreement from 1988 between the U.S. and Canada. And it's been important because it served not only as the largest trade bloc within North America and a very influential regime for trade between the North American countries, but also because it's been the template for quite a few other free trade agreements. There's a Central American Free Trade Agreement between the U.S., Costa Rica, the Dominican Republic, El Salvador, Guatemala, Honduras, and Nicaragua called CAFTA-DR. And then there are quite a few bilateral agreements that the U.S. has entered into. You can see the countries there, but they're all premised and formatted based on NAFTA. At one point, it did eliminate tariffs in the free trade area. Of course, tariffs were reimposed, especially upon steel and other industries that were considered vital to U.S. national security in the run-up to the negotiation of the USMCA. The structure of NAFTA, it has quite a few different chapters. It deals with, of course, trade issues, but everything from labor and environmental law to intellectual property law. And it kind of has fundamentals of all the different areas of intellectual property that would be governed by the agreement. And it creates kind of the format to apply the inspiration that the U.S. was pushing for stronger intellectual property protections for what it was seeking to have the other two countries adopt. So we're going to talk about these topics with regard to intellectual property. There are other topics within intellectual property itself in NAFTA, but they are things like satellite transmissions and other areas that are going to be less important generally. Let's start with the treaties. NAFTA itself actually requires the parties to enter into certain treaties or at least give effect to the substantive provisions. The 1971 Geneva Convention and Berne Convention, both of which relate essentially to copyright. One exclusion there that the U.S. preserved was that it was not required to protect moral rights under Article 6B of the Berne Convention. The U.S. doesn't have a general moral rights provision in its copyright laws the way that other countries do, especially European countries who sometimes protect it sui generis apart from copyright. With regard to patents and trademarks, and the UPOV Convention with regard to new plant varieties were also required either accession to the terms themselves or putting substantively similar terms in place. For example, Mexico did not accede to the UPOV Convention. And in a pattern that we will see later with especially the USMCA, it was not required to adopt the provisions immediately. it had 2 years to run up and adopt the provision. One of the keys for all of these provisions, starting with the Paris Convention in 1883, is national treatment. The parties are required to treat nationals of any other party, any other nation that's a treaty party, no less favorably than its own nationals. Now, there are very limited exceptions. For example, if you don't have to register an agent within your jurisdiction as a national, you may have to be registered as a foreign national. That's just to allow service of process and enforcement of rights. One other exception that NAFTA had that is not carried over later in the USMCA, we'll see, is that performers' rights regarding secondary uses of sound recordings could be limited to nationals. So that was a fundamental difference between nationals and foreigners, foreign nationals under NAFTA. Turning to copyright, the scope of copyright was intentionally expanded by NAFTA. The parties were required to allow protection, allow copyright coverage of all works covered by Article 2 of the Berne Convention, which included computer programs and compilations of data. Especially compilations of computer data were not protectable in all 3 states at that time. And one of the key provisions was that copyright term had to be based, if it were based on the life of a living person, a natural person, it had to be at least 50 years from the first authorized publication, or if there was no authorized publication in a party state, 50 years from the original making of the work. This was important both outside the U.S. and within the U.S. The U.S. actually had copyrights that had lapsed, and under NAFTA, it was required to restore copyright in certain movies, motion picture works that were produced in the 2 other territories. So it had a substantive effect on rights within the U.S. NAFTA kind of had this hit and miss approach. It didn't include a basic system that would be required. With regard to trademarks, it actually did. And one of the first things that was important was that anything visually perceptible had to be protectable in a trademark system. Now, at that time, that was kind of the snapshot of the law in many countries. It was starting to change in the U.S. so that auditory trademarks could be protected, but that was not required of the other states. And of course, the basic protection of trademark law is that you can prevent others from using your mark or similar marks that cause a likelihood of confusion among the relevant people who may be the public, or it may instead be some more limited group. And NAFTA required the parties to establish a registration system. So trademark law can either be common law or be based on trademark registrations. And all 3 parties were required to develop and begin to implement a trademark registration system that included the fundamentals: examination, notice to an applicant if there was a refusal to register, preferably in writing, an opportunity to respond to that refusal, publication to the rest of the public after registration promptly or before registration, so that they could either oppose or be on notice when they're selecting their own marks. And after registration, a reasonable opportunity for interested parties to petition for cancellation. One of the interesting things about trademarks under NAFTA is because there are 3 official languages in the 3 states, English and French in Canada, English in the United States, and Spanish in Mexico, any generic designation of goods or services in any of those 3 languages could not be registered. So in the U.S., you couldn't register even a Spanish or French generic designation of goods or services. So the terms of the trademark system actually were spelled out in even more granular detail. Registration actually can depend on actual use, but filing of an application cannot depend on actual use. So you can file what's called in the United States an intent to use application and prosecute it to get protection before you launch your product or service. And that had to be available in all 3 states. As long as you are committed to using the mark within 3 years. If you don't start to use it within 3 years, the trademark can be revoked or canceled. Registration has to be for a term of at least 10 years and renewable infinitely for additional 10-year terms, but it can't be a registration to, again, this is a snapshot that has changed since then, anything like immoral, deceptive, scandalous marks or goods that because of their nature, you would view as illegal or immoral or anything of that sort. So there could be services that you could get a trademark on even if you couldn't necessarily perform the services unless it related to something immoral, deceptive, scandalous, or disparaging of a natural person. While use wasn't required for filing an application, it is required under NAFTA to maintain the registration. So if you don't use a mark for at least 2 uninterrupted years, the trademark can be canceled. And then one of the other key terms is there can't be any encumbrance upon use that is special to foreign nationals or the specific type of goods. And you can't require compulsory licensing. You can't, as a state, force a trademark owner to license to a third party, including the government, with some very limited exceptions. With regard to well-known trademarks, it incorporated the Paris Convention terms. So that actually is not something additional that NAFTA required, except that it already required you to accede to the substantive terms of the Paris Convention. Turning to patents, the patent system was required to have the same kind of fundamentals. Now, at the time that NAFTA was adopted, was signed, and the enforcement legislation went into effect, the U.S. had a fundamentally different patent system from Canada and Mexico. It had a first-to-invent system. So there were certain parts of the patent system that were not addressed at all in NAFTA. The subject matter was patents had to be available for any invention. Now, invention, of course, takes care of 101 in the United States, but it had to be new and not obvious in the United States or result from an inventive step, which in the treaty are designated as being, if not identical, at least substantially similar terms. And then, of course, it had to be useful or capable of industrial application. which, again, if not identical, are substantially similar. There are some limited exceptions. If it would cause harm to the public, either order public or morality, if it was a method of treatment of humans or animals, diagnostic, therapeutic, or surgical, non-microorganism plants or animals, but of course, because the UPOV either had to be acceded to or the substantive terms had to be adopted, there had to be some sort of plan for protecting plant varieties. And you were able to exclude essentially biological processes for production of plants or animals. The bundle of rights that a patent owner obtained are a little more limited under NAFTA than under U.S. law. So for a product, for example, offering for sale or importing in the U.S. into the U.S. are prohibitions that a patent owner can enforce through their patent rights, but they aren't required under NAFTA. And so for a process, in parallel, it's the right to prevent others from using the process or using, selling, or importing the product made by the process. Again, more limited than U.S. law at the time and now. The treaty required patent rights to be transferable either through assignment or a transfer by force of law, as well as by a license. And there are two grounds for revocation that were spelled out in NAFTA. If there were existing grounds that would have justified the refusal to grant, for example, lack of novelty, obviousness, or failure to satisfy the description requirements, or if a government wishes to get rights under the patent and a compulsory license hasn't led to the exploitation. Now, this is kind of more important now, especially because of the pandemic we're in right now and the fact that NAFTA is the governing law. But there are limited exceptions to the exclusive rights as long as they don't unreasonably conflict with normal exploitation. This can be the government itself or allowing a third party to make, use, or sell something within the scope of a patent without the consent of the patent owner. But it's very narrowly limited. The unauthorized use, including government use, is permitted only if it's determined on a case-by-case basis. You first try to get authorization. You go to the patent owner and seek to license it, and they say no. It's got to be of limited scope and duration, non-exclusive, non-assignable, and compensated, and it can only be for the domestic market. So, for example, if there's a design patent on masks or a patent on a pharma product, you can't exploit that without the consent of the patent owner for use in the export market as well as the domestic market. And all of these characteristics have to be subject to judicial or independent review. Now, one of the unusual things about NAFTA, of course, in the U.S. we have a robust system of discovery, but NAFTA required a burden shifting in litigation if you couldn't obtain sufficient information with regard to a process patent, something basically that's being done secretly in a factory. If the product is new, if it wasn't made before the patented process, and there's a substantial likelihood that the plaintiff shows, the patent owner shows, that there's infringement, and despite reasonable efforts you haven't been able to show it, the burden would shift in litigation. Finally, two other key terms under NAFTA. Patent terms had to be at least 20 years from filing or 17 years from grant, and they may be extended for regulatory delay. There were no details of the potential extension, but there's the possibility that is spelled out. With regard to trade secrets, at the time that NAFTA was signed, remember, the U.S. didn't have a national trade secrets law. So what it required, what NAFTA required, is an adoption of the fundamentals of what was then only the Uniform Trade Secrets Act, that they're protectable if the information is not generally known or readily accessible to persons who normally deal in that kind of information, that the information has value, commercial value, and that reasonable steps have been taken to keep it secret. There's no term for trade secrets under NAFTA. They can be eternal as long as you maintain the secrecy. But one unusual provision in NAFTA is that trade secrets can be required to be evidenced in writing, whether that's virtual writing, a computer program, or on paper to be protected. That is not the law under the Uniform Trade Secrets Act or now in the U.S. under the Defend Trade Secrets Act. States could not discourage licensing through discriminatory or excessive conditions or anything that would dilute the value of the trade secrets. And NAFTA handled this issue within trade secrets. That is, what do you do if data has to be shown, data has to be submitted to show safety and efficacy for an animal product, an agricultural product, or a pharmaceutical product? Well, the parties themselves have to defend against disclosure and can't allow others to have access to that information for 5 years under NAFTA, which is in line with U.S. law today. And there, of course, are possible exceptions for very limited purposes. One of the other interesting things about NAFTA is it discussed geographical designations without having a framework for protecting them. Of course, most of them are protected under trademark law, but it had extensive discussion of how you could challenge geographical designations. So if something is geographically misdescriptive, if basically it's you're selling Vermont maple syrup that's made in New Hampshire, or it's geographically descriptive but misleading, or if it constitutes unfair competition, then there has to be some framework for allowing interested persons to challenge that either administratively or judicially. The parties cannot allow the registration as trademarks of misleading geographically misdescriptive designations. So not only is it something that can be challenged by interested persons, but also by the countries themselves. They're prohibited from registering those marks as trademarks. And nothing in this was required to be retroactive as long as the mark was in use for at least 10 years or was in use in good faith, or if there was a prior registration. But, of course, there's no requirement to protect something that is previously unprotected. NAFTA did also require a system for protection of industrial designs, whether it's patent or in doing that, it required protection of textile designs, and basically if it allowed patterns, you could prevent others from using your pattern on some article, that is being used for commercial purpose. You may not be able to prevent it under sort of the fair use kind of standards, where it's being used for a non-commercial purpose or something of that sort. NAFTA also had very extensive provisions for enforcement. I'm not going to go through them here, but it both was substantive and procedural, and it required the enforcement mechanisms to allow for judicial review and have very specific procedures that would protect the parties in any litigation. Written notice, the ability to be represented by counsel, the ability to present evidence, and some way of protecting against the disclosure of confidential information. And the remedies available had to include damages, provisional, and permanent injunctive relief, as well as the possibility of criminal process, at least for counterfeiting and piracy, copyright, trademark and copyright, counterfeiting and piracy. So that's the framework of NAFTA, and that is kind of the background of where we're starting. At this point, we've reached the first poll question. If you could enter the word trade into the WebEx poll, I will go silent for a little bit to give you the opportunity to do so. Okay. Now, NAFTA was kind of the granddaddy of all of the treaties and trade agreements that we're talking about. And here's the timeline. There's a big jump between NAFTA and the TPP. TPP had 12 parties that were forming this trade bloc that spanned the Pacific. But notably, one of the biggest trading partners, China, was not included. About half the parties already had free trade agreements with the U.S. Australia, Canada, Chile, Mexico, Peru, Singapore were all trading partners with the United States under free trade agreements. So it was expanding the group to around 40% of world trade. But although the U.S. signed in 2016, it withdrew in 2017 as one of the first moves under the Trump administration. And the other parties, they took an interesting approach. They decided they were going to use the framework of the TPP, eliminate certain provisions that the United States had negotiated for, and join in an agreement themselves. So that's what the CPTPP is, or the TP11. It has very substantial parts of the TPP still in place. Some of the IP provisions were the most controversial. The U.S. was requiring enhanced protection for intellectual property, and some of that was very controversial in the other countries because it was requiring them to bring their protection up to the levels of IP protection in the U.S. Well, the importance of the TPP and the, let's call it TP11 here, are that it served also as the basis for the USMCA. That is, the U.S., Canada, and Mexico took the format of the TPP and used that as the basis for negotiations. which makes sense because the standards that Canada and Mexico have to meet under the CPTPP are going to be in place already. And that made the negotiations easier in the replacement for NAFTA. As we'll see, the last of the agreements, the U.S.-China bilateral agreement, has a very different format. So, as I said, the structure of the USMCA is based on the TPP. Most of the provisions are identical or nearly identical to the TPP, and I'll point some out later, but there are some major exceptions. So one of the things that the U.S. was trying to push for in the TPP is patentability of not only new products or new processes, but the new uses of known products. For example, something like Viagra, which at one point was the best-selling drug in the world, was an old drug that had been repurposed. And it was the new use of the known product that allowed its protection in the U.S. and its exploitation by Pfizer to make a lot of money. And that has been excluded from the CPTPP and the USMCA. Biologics patent provisions. Again, this was one of the most controversial aspects of the TPP. It had a framework for the protection of biologics that is separate from the rest of the patent terms in the treaties. And that's been excluded from the USMCA, and it's been excluded from the CPTPP. It didn't rise to the level of protection under U.S. law. The data exclusivity under the biologics provision was for 5 years, and the exclusivity for coming to market was 8 years. But it was substantially higher than in many of the signatory states. There was a provision in the TPP for data exclusivity for clinical data related to a new indication for an existing drug. So if you are seeking a new indication in the United States, there is a period of data exclusivity that protects against the disclosure of that information, so that even a generic that is already on the market for a different indication cannot use that data to change its label. It's 3 years for new clinical investigation exclusivity in the United States. And that was the plan, but that, of course, is not in either the CPTPP or the USMCA. And finally, there was a provision that related to first inventor to file. And because the U.S. was the only state that had first inventor to file provisions, that was excluded. If you look, the USMCA has a format that is very similar to NAFTA in terms of the subchapters, the articles within the chapter. And the reason I put this up is because it's fundamentally different from the bilateral agreement with China that we will get to. In the USMCA, the parties have to accede to all the treaties in NAFTA, except for the 1971 Geneva Convention, which relates to copyright. But as you can see, the WIPO Copyright Treaty and the WIPO, which is the World Intellectual Property Organization, Copyright Treaty and the Performances and Phonograms Treaty are required for accession. Those two supersede the Geneva Convention with regard to the treaties to which you have to accede. It's a mixture of things that were in place before NAFTA, the Budapest Treaty and the Madrid Protocol, and the PCT, the Patent Cooperation Treaty, and things that came afterwards. And the two treaties that are highlighted in red here, the Hague Agreement and the Patent Law Treaty, those were not required under the TPP, but they are required now. There is a phase-in period for the parties to accede to these treaties to the extent they aren't parties already. And for the Patent Law Treaty, as it says here, you have to adopt at least the procedural standards. You don't necessarily have to adopt the treaty itself. So with regard to national treatment, the fundamentals are similar to what is in NAFTA, but the exclusion for secondary uses of copyrights has been excluded from the USMCA. So treatment of foreign nationals has to be no less favorable than a party's own nationals, except that you can have certain limited situations like appointment of an agent for receipt of service of process. One of the other things that didn't exist at the time of NAFTA, really, is an obligation to publish online. And there are plenty of provisions of the TPP and CPTPP and USMCA that relate to moving systems online. It's important because it creates easier access, especially in the other states, to the law of the other parties. So the laws, procedures, regulations, administrative rulings of general application, public information regarding patents, trademarks, copyrights, geographical indications, designs, industrial designs, that is, and plant variety rights, and the public information about the granted rights, so that the public can know. So you can research as a member of the public to see if you want to use, for example, a given trademark in Canada or Mexico, because that information is going to have to be available online. Again, there's a phase-in period for development of these publication processes as well. Probably the most controversial provision of the USMCA outside the U.S. Is what, when it was adopted in the U.S., was called the Walt Disney Law, or the Mickey Mouse Law, which is the lengthening of the term of trademarks. The term of copyrights. It was done after heavy lobbying by the Walt Disney Company to protect the image of Mickey Mouse from its first use. And we've gone from 50 years after the death of a natural person to 70 years. It's not less than 75 years if it's, for example, a work made for hire, where you're going to calculate it in a different way. Now, this is even longer than the TPP, which had only 70 years from the end of the calendar year of the first authorized publication. And this is going to require Canada and Mexico to extend their copyright term. There's 2.5 years before they have to adopt the legislation that will allow them to do so, but the rights are retroactive. So even if it takes some time, ultimately the protection will apply to anything that falls within the scope of these provisions. One of the other very controversial provisions in TPP that is in the USMCA are detailed provisions for what are called technological protection measures and rights management information. This is, for example, the coding that prevents easy copying of electronic files, sound files, movies, computer programs, things like that. The parties have to put in civil and criminal penalties for circumventing any effective technological measures that control access to protected works. So this is a clear attempt to allow rights holders, copyright holders, to continue to protect their rights against piracy. And that TPM provision has to be a separate cause of action from copyright infringement. So you don't have to prove that somebody has themselves made a copy or distributed the work. The mere fact that they have removed the protective measures, the TPM, is a separate cause of action. Rights management information is the stuff that you see at the beginning of movies, for example. You know, the company that has published the film, the person who wrote the screenplay, the director, things like that. And there has to be penalties, both civil and criminal, if you remove or change that. If you make it seem like somebody else is the one who should get compensated, or if you remove the information so that people can't identify who the party that should be compensated is. Or if you facilitate the copyright infringement or distribution. So this was very controversial in TPP. It's a little less so with USMCA, although the commentators, especially Canadian commentators, were very much opposed. With regard to trademark law, USMCA reflects the change in trademark law that occurred between the time of NAFTA and the time of the USMCA. Trademarks don't have to be visually perceptible anymore to be registered, and that's written into the treaty. Sound marks have to be permitted to be registered if they otherwise would qualify as trademarks. And to the extent they can, the parties have to make an effort to register scent marks. But one of the protections that's available in U.S. law and wasn't necessarily available in Canada and Mexico is with regard to well-known marks. They don't have to be registered under the USMCA now to be given protection as a well-known mark, meaning that you can not only prevent confusion with regard to the goods or services that you're providing or that the other party is providing that are substantially similar, but, for example, an endorsement with regard to some other completely unrelated form of goods that people would think existed. There doesn't need to be any form of protection beforehand to be considered well-known. There are extensive provisions relating to the requirements for examination, opposition, and cancellation. And there's also substantial information related to a means for challenging domain names. It has to be quick, cheap, fair, equitable, and not prevent parties from going to court to protect their rights. Patents are actually the largest part of the USMCA's intellectual property rights provisions, and they're broken down into general, agricultural, and pharmaceutical. Generally, the same subject matter is protectable under USMCA as it is under NAFTA. But USMCA has a provision that requires all 3 states to adopt kind of this protection that the U.S. gives to the first inventor to file. That is, you don't lose your novelty rights or inventive step rights. You don't have information cited against you if you made the disclosure yourself within 12 months of the filing, or if somebody directly or indirectly obtained the information from you and then made that public. The grounds for cancellation or revocation are expanded here and changed slightly. So fraud, misrepresentation, or inequitable conduct is now a grounds for cancellation or revocation. And it substitutes Article 5A of the Paris Convention in the place of a compulsory license. So that's a slight change, but the new grounds of inequitable conduct or fraud are a change from NAFTA. And this is a fundamental difference from the existing Mexican law. Parties have to have at least one opportunity to amend, correct, or make observations. You were able to make typographical changes, something of that sort under Mexican law, but this is substantive amendment, substantive correction, or make some sort of argument under the patent law. And instead of just a possibility of patent term extension which is what existed under NAFTA, now the USMCA requires patent term extension for prosecution delay and spells out expressly that unreasonable delay is at least a delay of 5 years from filing or 3 years from a request for examination, but that doesn't count things like the applicant's delay, other delay that's not attributable to the granting authority, or time that is not related to the processing or examination of the application. So it requires all 3 countries to have a system in place that is at least that protective. With regard to regulatory delay, there has to be some system. Now, it can be sui generis. It does not have to be additional patent protection. And there isn't this clear express identification of what undue delay would mean with regard to regulatory delay. Instead, there are a few conditions and limitations that might be helpful for determining what would be unreasonable regulatory delay. First of all, it can be limited to a single patent term adjustment for a pharmaceutical product. It can be based only on the first marketing approval granted to that pharmaceutical product. It can be limited to an adjustment of a maximum of 5 years. Regulatory delay could be far longer than that, but it can be limited under these guidelines. And if it's protected sui generis rather than under the patent system, it could be limited to a maximum of 2 years. The USMCA protects the confidentiality of submissions to agricultural and pharmaceutical regulatory entities in a way different from NAFTA. It doesn't talk about it in terms of trade secrets. It talks about it within the patent provisions. And it expands not just from safety and efficacy data, but also evidence of marketing approval. For agricultural chemical products, in NAFTA, it was 5 years that you had this exclusivity. Under the USMCA, it's 10 years. But for pharma products, which includes biological products, it's 5 years. So all 3 states have a minimum of 5 years of data exclusivity already in place. So this is not something new or more onerous, unlike what would have happened if TPP had gone into effect. And this is in line with the new chemical entity exclusivity under U.S. law. One thing that's spelled out expressly here is that if there's a patent and it's expired, that doesn't affect this data exclusivity, which is in line with U.S. law, but it is something that now expressly applies in all 3 states. With regard to trade secrets, there is a substantial change as well, not with regard to the type of trade secrets that are protectable or their duration, but first, any trade secrets, even if they're not in writing in any way, are protectable. And there's a difference between the USMCA and NAFTA in relation to especially criminal law. Misappropriation is defined in a manner similar to the USTA or DTSA, which didn't exist until right before the signing of the TPP. So the U.S. didn't have a national trade secrets law at the time this was being negotiated. So the treaty, TPP, and now USMCA expressly say that this civil protection doesn't have to be federal. It has to be nationwide. So every province of Canada, which doesn't have a national law, would have to adopt something that allowed provisional measures, for example, preliminary injunctions and temporary restraining orders, and would both protect confidentiality and enforce that with sanctions. But the criminal law doesn't have that same exclusion that allows non-federal protection of trade secrets. So Canada is going to have to adopt a national trade secrets law. Moving to geographical designations, the big difference here is that instead of focusing on when you wouldn't protect them, it focuses on when you would protect them. So that's a substantial difference between NAFTA and the USMCA. There's got to be some administrative system. It can be trademarks. It has to be online and available. Interested parties have to be able to object, and judicial review has to be available. But one of the interesting points is that you can't get protection before filing or the registration date, depending on what's applicable under the state's law. And then with regard to industrial design, there has to be an electronic system for seeking to protect industrial designs. There's a parallel provision in the USMCA for your own disclosure or a disclosure that comes from you, not rendering your industrial design obvious or non-novel. And there's an express indication that there has to be a term of protection for at least 15 years from the date of filing or the date of grant or registration. Of course, a patent system can satisfy this. The enforcement mechanisms for the USMCA are even more detailed than they are for NAFTA. It includes specific remedies. It includes, for example, the possibility of statutory damages or alternatively punitive damages for piracy and willful trademark infringement and willful patent infringement. So it is very extensive and is going to require the adoption of substantially more detailed provisions for the civil justice system and criminal justice system, especially in Mexico. The U.S. doesn't really have to adopt anything because it was in the TPP bringing others up to its standards in the courts. Now we've reached the second slide. Please enter the word trade into the WebEx poll and hit return. And we'll pause here before moving on to the U.S.-China trade agreement. Okay. Now, the U.S.-China trade agreement is fundamentally different from any of the agreements we've talked about. It's very recent, and it is less detailed, and it may have issues with the implementation of the terms because trade has been substantially diminished or cut off due to the pandemic. You can see just from the title of the articles within the intellectual property chapter that it is very different. I mean, things like piracy and counterfeiting on e-commerce platforms, bad faith trademarks. These things are not the same as the multilateral obligations that exist under the USMCA and NAFTA. And that is very clear because for many of these articles, it has requirements for China, but the U.S. then affirms that existing U.S. measures, for example, afford treatment equivalent to that provided for this article. So article after article, the U.S. doesn't undertake any additional obligations from what it already has. With regard to trade secrets, it expands what China has to consider trade secret misappropriation. It calls for a shifting of the burden of proof if you show access to the trade secret, use of information that is materially the same, risk of disclosure to third parties, and misappropriation, that it's been obtained in some improper way. And China generally doesn't require preliminary relief. Well, the agreement now says, based on the facts of a case, generally you're going to have to consider it an urgent situation, which is required for the showing of relief under Chinese law. One of the other things that is required for a criminal referral is that there has to be great loss from the trade secret misappropriation. Well, what the U.S. tries to do is prevent that great loss from ever happening. So you can be criminally liable even if the trade secret owner never loses the value of their trade secrets. The first step is going to be that before changing the law substantively, legislatively, China has to say that remedial costs can be considered a great loss. But ultimately, they have to get rid of that requirement. And they have to expand what would be subject to the criminal law. And one of the problems that's occurred in Chinese criminal enforcement, and one of the deterrents to enforcement, has been that there's been disclosure, either to competitors or the government, and China has to put in a position, a way of preventing that for people not to obtain the trade secrets through litigation, including financial penalties and potential criminal, civil, and administrative penalties. With regard to pharma, China has to require pharma applicants to be able to rely on supplemental data after they file the initial patent application to satisfy things like inventive step or sufficiency of disclosure. So show that the disclosure is enabling. They must be able to submit additional information, as well as in, for example, litigation. And for biosimilars and generics, China has to put a system in place that allows notice and challenge for the patentee before the generic or the biosimilar comes to market. The rest of the provisions relating to patents in the patents chapter itself is limited to patent term extension. And the terms here are a little different from the USMCA. Prosecution delay starts after 4 years after filing or 3 years after the request for examination. Remember, it's 5 after filing under the USMCA. And there is expressed possibility for the limitation of unreasonable regulatory delay. With regard to e-commerce, it recognizes that the two countries have to cooperate, but it also it requires China to put in place a notice and takedown system like the U.S. has. It has to be expeditious. China now discourages the filing of takedown notices by having the possibility of liability for a good faith but erroneous takedown notice. So if you're merely wrong and don't do it in bad faith, that shouldn't be the basis for liability in China under the system. And on the other hand, there should be liability for bad faith notice, takedown notice, or counter notice. So they have to put in place protections on e-commerce platforms and have to create the possible threat that you will potentially lose your operating license if you don't curb piracy and counterfeiting. With regard to geographical indications, this is very different from the USMCA in that it gives the U.S. a veto power over China agreeing with third parties to adopt new indications. If there's something that is not in existence now, if the U.S. wants market access to the goods and services with those terms, China cannot enter into a treaty with a third party to limit the market to the U.S. And it gives guidelines that are similar to what exists under NAFTA and the USMCA for how you determine whether a term is generic. Now, one of the things that is different there, though, is this Section D, whether the good is imported into China in significant quantities from somewhere other than the geographical indication, in a way that doesn't mislead, or if the goods are named by that term. Something like cheddar cheese, which originally came only from Cheddar, England, but now is somewhat generic and is imported into China from the U.S. With that designation. One of the other things that China has to do is allow for the cancellation and limitation of marks, geographical indications. Now, with regard to pharma, it's been a big problem that private entities and governmental entities have created counterfeit pharmaceuticals. So China is required to start taking additional steps and prove that it's taking additional steps by publishing online its enforcement measures. It is required to significantly increase the number of enforcement actions. It's required to add additional persons enforcing at the border as well. And if China sees goods entering the flow of commerce at the border, it has to, and I apologize that my slide advancement continues to try and walk backwards. It has to destroy goods. It can't potentially permit the export of those goods. There's been a wink and a nod system that the U.S. has argued exists in China, and they have to now start destroying themselves things that they see that infringe trademarks or copyrights. They have to allow for civil judicial proceedings that will call for the destruction of counterfeit or pirated goods without any payment to the pirate or counterfeiter. And they have to destroy the goods ultimately in criminal proceedings and keep them in evidence and have a register so they don't disappear from criminal proceedings. And there's a timeline that's set into place. 3 months, so that's May of this year. By May of this year, China must significantly increase the number of enforcement actions at the border and publish those online. By June, China must significantly increase the number of enforcement actions at physical markets within China and publish online. Within 7 months, that's November, China has to begin requiring annual audits by third parties, independent third parties, of its own government agencies to determine if they have proper software licensing in place. Because software piracy within the governmental entities is seen as a big problem. And then within 9 months, essentially at the end of the year, China must provide a sustained increase in its border personnel. So it's got a ramp up time to hire, but it's got to have in place, basically at the end of the year, a robust protection system. And there are specific and clear judicial enforcement mechanisms that are required. There's also a timeline set forth in the treaty to describe the steps that have to be taken. There's a lot more in all of these provisions, all of these treaties, and I would love to discuss it with any of you. I appreciate the time you've taken to come and listen in to hear the fundamentals of these agreements. And if there's anything more that you'd like to know or any way we can help you, feel free to reach out. Here's my contact information, and feel free to contact us at MBHB. We're on all social media platforms and would love to hear from you. Thank you very much.